Thank you. Good morning, everyone. Good afternoon, also to people who have joined us from abroad. I am KPS Kohli. I'll be the moderator for the session for today. Uh, Before I start this session, there are a few housekeeping rules uh, regarding how I intend to take the webinar forward. One is that there is a Q&A box that you see on your screen. Feel free to put in your questions on that box. And after the webinar, I intend to take certain questions and share and ask my panelists for it. And I'll be taking through the webinar, and I'll be putting the questions to the panelists. And I straight away go to the I'll start the session. The modern commercial arbitration, as we understand and practice today, has taken centuries to evolve, and it continues to evolve even today. The need for commercial arbitration has its genesis in the man's quest for enterprise. With the rise in civilizations, businesses thrived. However, with the rise in commerce, the commercial disputes increased. Toils from the disputes contributed to the evolution of the commercial jurisprudence, which has the basis for international commercial arbitration. And this is what I intend to discuss with the panelists today, as international commercial arbitration, or arbitration as we understand, is probably the most efficient mechanism to resolve commercial disputes. And in today's global world, the role of international commercial arbitration cannot be stated less. I mean, to resolve the disputes internationally amongst parties, I think rather than going to jurisdictional courts of different countries where there could be allegations of home bias, I think international commercial arbitration has come up as the most efficient method where parties can get an effective remedy and a resolution. And with the unicitral model, which is followed across majority of the world, you can also are assured of your execution and the results and the fruits of your toil during after the arbitration. So, but with the pandemic happening, I think there has been a lot of change in how we conduct the arbitrations today, domestically and internationally. With the pandemic, I think across the world there has been restrictions. Countries have been put under lockdown, and severe movement restrictions of people, which has affected not even the conducting of the business, but also how we conduct our dispute resolution mechanism. And that is why we thought to organize this webinar. And I have very erudite speakers. One is Ms. Maneesha Dhir, and my friend from Singapore is Mr. Ajinderpal Singh. So Ms. Maneesha Dhir is the managing and founder and managing partner of Dhir Dhir Associates. Ms. Dhir is highly reputed litigation lawyer with over 3 decades of expertise in handling wide range of cases in commercial litigation, arbitration, both domestic and international, insolvency laws, telecom laws, M&A, corporate consultancy. She's a regular speaker at various global conferences, and she has been bestowed with many awards and has received many accolades for her varied contribution, such as National Bar Award by the All India Bar Association in recognition of her dedication to the study of commercial litigation, Women Lawyer of the Year 2020 award by the Public Diplomacy Forum, ranked among India's top 15 dispute resolution lawyer by Asian Legal Business, besides being recognized as a leading lawyer by Chambers and Commerce, IFLR, Legal 500, Indian Business Law Journal, Asia Law Profile. She is a co-chair of IWIRC India Network since its inception, and vice president of Women in Law and Litigation, aimed at encouraging women to achieve excellence in the field of law. My second panelist for today is Mr. Ajinderpal Singh. Ajinderpal is a senior partner in the litigation and dispute resolution and arbitration practice group at Dentons Rodyk. Ajinderpal practices focused on partnership and shareholders dispute, insolvency, and banking litigation. He has acted for both minority and majority shareholders, representing a diverse range of clients, including public listed companies, foreign joint venture partners, and homegrown family businesses. He has been involved in partnership disputes between local law firms and international firms. Ajinderpal has a broad-based diverse range of arbitration experience. He has been involved in ICC, ICAC, and ad hoc arbitration. He is well versed with issues related to enforcement of legal awards, including applications for setting aside such awards. He has presented represented an investment fund vehicle against a local listed company in dispute over investment in a condominium development project. He has acted for major Japanese institution against an Indonesian joint venture partner. Ajinder is a fellow of Chartered Institute of Arbitrators, Singapore Institute of Arbitrators, and an associate of Insolvency Practitioners Association of Singapore. He is recognized by Chambers and Partners and IFLR for its restructuring and insolvency work. Additionally, benchmarks litigation ranks Ajinder as a dispute resolution star in commercial and transaction and insolvency. So I have a very erudite panel with me today on to talk about arbitration and how the virtual hearings have been affected, or how we can actually ensure that the virtual hearings are expedited, are more efficient, because probably virtual hearings is a new normal. So before I delve into the question, probably I want to ask Ajinder first on what is his experience during this pandemic. And I realized that Singapore was under a complete lockdown for about over a month, and I think now the restrictions have been eased a bit. So during all this period, I want to understand from you what has been your experience in conducting virtual hearings, virtual arbitrations.
Thanks, KP. Good morning to everyone, and it's afternoon here for me. This pandemic has actually accelerated the development of virtual arbitration. Virtual hearings, virtual arbitrations are not new in the sense that already over the years, we can see a small shift towards that. What do I mean? For example, in the 80s or 90s, parties would have to fly to the UK or New York or wherever your international arbitration was going to be held for even small conference meetings to decide procedural timetables. From there, we evolved to doing such small conference meetings by way of phone or virtual hearings. But now with the pandemic, everything is going virtual. Why? Because of the lockdowns in every country and the restrictions on travel. So for us in Singapore, we have experienced these virtual hearings in two ways. Everything that is before the courts is going through virtual hearing. Second is even arbitrations are going through virtual hearings. This by itself presents its own problems because, for example, just last Friday, I had a hearing whereby we are here in Singapore, the arbitrators are in Paris, and another set of the lawyers are in Kazakhstan. So timing was an issue. So what happened then, we had to compromise. We in Singapore had to take the call at 8 p.m. our time. And the hearing went on for a little bit longer than expected. It ended at 10 p.m. at night. So this is the new norm. Instead of working from 9 to 5, we have to shift our hours to accommodate the virtual hearings. And in terms of hearings, we will explore during this seminar as to how efficient is it better, is it worse, and how do you prepare for it? Because I can tell you, it takes a lot of work to prepare for a virtual hearing, but this is the future and this is only going to increase. So thank you again, KP, for letting me say a few words.
I have a lot to ask you during the arbitration, but before I come there, I want to ask Ms. Dhir what has been her experience. And in fact, Ms. Dhir has last week had a big success, probably the biggest arbitration award in a sports arbitration matter, about 8,000 crores for Deccan charges against BCCI, the Board of Cricket Council of India. So I just want to ask her what has been her experience in terms of doing virtual hearings, either before courts or before the tribunals. And I think for BCCI, for this Deccan matter also, there has been a virtual award pronouncement.
So KP, good morning to everybody. Thanks KP for mentioning that award. But interestingly, one of my biggest experience was the pronouncement of award on a Zoom call. And these matters were reserved some time back, but various applications were filed for not proceeding with the award. Eventually, the award got pronounced last week, and it was an award in favor of Deccan charges, and 8,000 crores was awarded. My other experience as far as arbitration proceedings considered is where partly we had conducted the hearing physically, but after the lockdown it was not possible. But during the pendency of that, to and fro agreements were being passed, and eventually on a video conferencing, those agreements were agreed, and in fact they were mailed to the arbitrator immediately at that point of time, and the award came in subsequently. These are the two recent experience I have had on virtual hearing of arbitration.
Great. So, in fact, I wanted to ask you further on this, that since both of you have experience of doing arbitration virtually, so how do you think can we make it more efficient in terms of, since virtual is a new norm, and as I understand, probably going forward, this is here to stay. So I think every calamity brings with it new necessity, and necessity is the mother of invention. So I think people have now started looking towards virtual hearings, virtual arbitrations, virtual international arbitrations. So what is, in your experience, Ms. Dhir, would be the most efficient way to conduct a virtual arbitration proceeding?
So KP, let Ajitha take that first, because I think Singapore is more streamlined in this respect. Ajitha, can you take that first with respect to how, and then I will discuss the Indian scenario.
Sure. Thanks, Mrs. Dhir. Just coming back to the question on how can we improve efficiency of virtual hearings. This is the hot topic of the year, because everyone is trying to see how we can better the system. And what I can point to all of you is this. There is this paper by the ICC. It is called ICC's Guidance Note on Possible Measures Aimed at Mitigating the Effects of the COVID-19 Pandemic. It's a very good paper, because it kind of describes exactly what parties should be thinking of in order to make their arbitration more efficient. For example, right now we are in different cities, in different countries, but we are connected through the internet. So the first thing the ICC says is the parties need to actually decide on what system are you going to use. First, you've got to decide, in terms of your arbitration, are you going to use Zoom, WebEx, and what do you do about your witnesses? What do you do with the bundles? For example, is there going to be a different sharing platform for bundles? So first, the first and foremost, you have to make it efficient is you got to think about the system and the configuration for your system. Then comes other issues like, witness cross-examination. If a witness cannot be in the same, for example, location as the arbitration, then what do you do? Do you want to have the right to have perhaps local representatives from the other party, the opposing party who's going to cross-examine, be present in the room with the witness while he's being examined to make sure he's not has access to different material, or he's not collaborating with somebody else on his answers? So things like that need to be sorted through before the hearing. Then the other issue is rights of audience. Who leads? Now it's very common. We have 5, 6, 7 lawyers in one team. So before the hearing, normally you have to decide who is the lead counsel, what rights does he have, is anybody else entitled to speak, and what is the protocol? For example, if somebody else is speaking and I want to interrupt because he's made a point that is fundamentally wrong, what do you do? Do you interject live like we are doing now, or do you do it on the side somehow? So there's a lot of thought that needs to be put in place, not a lot of thinking that has to be done before the hearing can take place. And what then is the recommendation? Actually, what this means is you have to come up with a cyber protocol. The cyber protocol lists out all of these things.
I'm sorry, I need to interject. Yeah. Can you please put on your mic a little closer to your mouth? I think there is some...
Sure.
Yeah, that's better.
It's not... is this better?
Yeah, absolutely. Sorry to interrupt.
Apologies for that, no problem. So what in effect we are seeing in international arbitration is a development of a need to draw up what is known as a cyber protocol to address all these issues. This is all well and good, because what I'm saying is basically this is party agreement on the protocol. The other problem is, of course, what if parties cannot agree? Then what do you do? KP asked the question, how do you improve efficiency? So if parties cannot agree, does that mean the hearing cannot take place? This is where I think there is a divide between international and domestic arbitration. At the moment, all of the rules, whether you go for institutional arbitration, whether be it SIAC or ICC, all of them have this very generic statement or generic rule that says the arbitral tribunal can decide on the procedure for the arbitration. Every institution has now come out to say this means then that every institution, every arbitral tribunal has the power to decide whether or not a hearing will be held virtually. So again, if a cyber protocol cannot be drawn up by agreement, then the recommendation is parties put their proposals as to how the hearing can take place, be it virtual or otherwise, and then the tribunal has to decide. And of course, under the rules, the tribunal can decide in favor of a virtual hearing regardless of parties' disagreement. Of course, now everybody in the audience and will be shocked because this means then your rights are being impugned. And what does that mean? Does that mean set aside becomes easier? But this is where, again, there's a big change in the international sector. Internationally, worldwide, people are becoming more accommodating of virtual arbitrations. So, for example, in the Singapore courts, unless there is something that has gone fundamentally wrong, meaning you can show obviously a witness was reading answers off a script, or in some other way was being fed answers, and therefore the cross-examination was ineffective, it will probably not be set aside. So this is where things are going in terms of virtual arbitration. It is a big shift, but again, on the flip side, in terms of efficiency, there is a bit of saving of money in the sense like, let's look at it this way. If we are doing this webinar in a normal climate, I would be there in India in a 5-star hotel as compared to sitting in my living room and having this seminar. So the same for virtual hearings. You can do it in your bedroom as well if you want to. So in that sense, that saving can be passed down to the consumer, the clients who need virtual hearings. And that's my little bit of intro into this topic. I hope that helps.
Yeah, definitely. So at least cost efficiencies are involved in virtual hearings. And I think you did made a very good point on the right of hearing. There are a number of lawyers whom to access, who can, since arbitrations are private mechanism to impart justice. Ms. Dhir, your take on it.
So my take on it is very interesting. I feel that unless the arbitration agreement itself excludes virtual proceedings specifically, according to me, it includes virtual proceedings. So a person objecting to that because it's a pandemic situation, the arbitrator can always overrule and say that the virtual hearings will go on, unless the contract specifically excludes it. Because a hearing means it could be physical, it could be virtual. And looking at the situation, the arbitrator, and looking at the urgency in the situation, the arbitrator can direct virtual hearings. Here I have only one thing to add is that it could be later. One of the grounds, I mean, this is probably one of the issues, that somebody may say that I never got a proper right to represent myself because it was virtually and all that, could be a difficulty later. But my understanding of the thing is that hearing does not necessarily mean a physical hearing. It can be a virtual hearing, and an arbitrator can direct for virtual hearing looking into the current pandemic situation. As far as costs are concerned, definitely costs have a lot of bearing. In fact, my understanding is I was speaking to Ajinder just now, and he was saying that the filing in has increased so much, I guess, because the costs of probably conducting an arbitration proceedings in Singapore have come down because of physically not to be present. Is that correct, Ajinder?
That's totally correct with you. And actually, I agree with your point that if the clause does not specifically exclude virtual hearing, then you can have a virtual hearing. But of course, right now, what is happening also is the recommendation is for new contracts. We try and make it crystal clear that virtual hearing is included. So the one guidance note is going ahead. Maybe we try and make our arbitration clauses wider and include virtual hearings to avoid the problem that you have just pointed to in terms of enforcement and setting aside. That's one party may claim my right has been infringed upon. I didn't have a proper hearing.
Yeah. So, I mean, there is one more important aspect in arbitrations, both domestic and international, is regarding appointment of an arbitrator. Whom do you choose as an arbitrator? And in my experience, personally, I can tell you that my matter was fixed for final hearing an arbitration fixed for final hearing, dates were given, and then the lockdown happened. And thereafter, we did had a communication with the tribunal, but probably it's not possible, it's not conductive of them, three of the arbitrator panel joining in virtually. So I'm talking about domestic arbitration. So my question is to you, Ajinder, and to Ms. Dhir both, in terms of what do you think that in view of this pandemic situation and now a new realization that this can happen anytime, in the sense that probably the virus can resurge. God forbid it doesn't happen, but if it resurges, let's say, and we have seen cases happening, we have seen re-lockdowns putting in. So what do you think would be the special considerations to be kept in mind for the at the time of nominating an arbitrator? So in my case, probably parties, my clients are pushing for an arbitration hearing, but it seems like we are stuck till the lockdown opens up and things ease up, and we 50 people can crowd in one room to conduct that arbitration. So what is your take on what should be the consideration to be kept in mind while nominating an arbitrator, having back of your mind that we may have lockdowns or parties may prefer to do to virtual hearing altogether, even if everything lifts up, everything goes back to normal. So what do you think should be the consideration for it?
Ms. Steve, do you want to take that first? Or?
So I'll explain it in the Indian context exactly. See, consideration for appointing an arbitrator, we cannot decide, because if there's a pre-existing contract or a procedure provided as to who the arbitrator should be, will have to be appointed in that terms of the arbitral tribunal. This is my view. Going forward, of course, where we're talking about ODRs and other things, then you can, as far as considerations for arbitrator to be appointed would be that they should be tech savvy and should be expert in that subject you're taking. I think that really works in terms of expeditious arbitration and in terms of virtual hearings. Because if an arbitrator is tech savvy and is an expert from that field, I think arbitrations can go on very well in the virtual field.
Right. Thanks, Ms. D. Actually, all that is correct. You need somebody who is legally tech savvy, experienced in his field and expert in his field. But recently, because of this pandemic, I have revised the list a little bit because purely my side faced the problem. We had this arbitrator on an oil and gas dispute. He was in his late 70s and he's based in Lebanon. He's an expert in this area concerning an oil field in Lebanon. But because we now have to do things with virtually. One problem is I have to select the time zone for hearings to suit his time, meaning we cannot have it later than 7, 8, 9 p.m. his time. Otherwise, the arbitrator may not be sharp enough to sit through the entire hearing. So nowadays, given what is happening, you need to consider the age of the arbitrator. You also need to consider how technologically savvy is he in terms of getting onto Zoom, using technology. Because again, this arbitrator was not very sound in technology and was having great difficulties logging on to things. So a little bit of that issue now is coming into the fore. And the other third thing is this, again, it's linked to the technology part. Now, of course, one big issue we have is how do we get bundles to somebody else in another country? This, again, bundle courier services within a country are fine, but externally there is an issue, there's a big slowdown, and sometimes in certain parts you cannot get physical bundles to the person. So you need to make sure your electronic platform is stable, it is private and kept to the parties, and at the same time that the other side, meaning your arbitrators or whoever needs access, are able to access it and know how to use the systems. Because otherwise, having an arbitrator with no access to documents, obviously he cannot make a decision that is useful to anyone. So this is the new thing that you need to consider. Given the pandemic, if you're going to go for a virtual hearing, is your arbitrator someone who is suited for virtual hearing? Can he follow online? Is he able to take different time zones? Because different parties now, you need to accommodate different timing. And generally, can he access things online? So these are the new criteria this pandemic has brought up.
So just one thing I was debating in my mind, that if there is a contract which agrees to arbitration tribunal in the contract itself and the procedure, looking at the new situation is can they consent to a new arbitrator because of the pandemic who has more tech savvy or otherwise. So I think we must explore this option also, that even if despite the fact in the contract there may be an existing procedure for appointing an arbitrator or arbitral tribunal, maybe this could also be explored in terms of seeing that who an arbitrator could be with the consent of the parties. Of course, it can be.
You're exactly correct. And this has a great impact even for us on domestic arbitration, because for us still, the choice for domestic is always a retired ex-judge. And unfortunately, they are not the most tech savvy. So, you know, what you say, Ms. Dhir, is actually important, that parties maybe have to think practically and try and consent to a change in these times. Otherwise, you won't get any hearing through properly at this point in time.
But and my question is to both the panelists on the next one, that under this scenario, what do you think that what are the kind of hearings that you think, what is the nature of hearings that you think can take place? Especially keep in mind that evidence collection could be a challenge in these times. So what is your view? I mean, if Ajinder, you want to take it up first.
Sure. Actually, at the moment, my own view is this, when you come to arbitrations, virtual hearings are best for hearings with legal issues only. Meaning, if it's something that can be done through documents or just on a point of law, people can hear arguments and have submissions before them. Those kind of not fact-intensive hearings are the best suited for virtual. Sometimes when you have, if you turn the page to a hearing, a full hearing where there is need of cross-examination, this can be problematic, because while I've made the point that your arbitrator, at least you can choose, if, and KP, we were talking about this just before, your experience, if you have a witness who is slightly older and you cannot choose the witnesses, are they able to take a virtual hearing? Are they able to perform? Put aside the issues on cross-examination and needing to make sure that they are not tampering with the evidence or collaborating. The other problem is the witness themselves. Can they perform for cross-examination virtually? It may be a problem. So to me, while I've said virtual hearings is the norm, my preference would be to try and have it just for documents only or legal issues. And if I can avoid a virtual hearing where arbitration is, cross-examination is needed, that would be my own preference. But again, given these times, it may not be totally possible.
Right. Ms. Dhir, what
What
you think would be an appropriate hearing?
So what Ajinder is saying is absolutely correct. Expert-based or document-based and all that, if the virtual hearings are conducted on that basis, I think it is perfect and it can go very expeditiously. But where cross-examination is required and where witnesses have to be examined, I think it's a bit of a challenge, because like you said, tampering or tutoring is possible at that point of time. But recently, about some time back, we did a matter where cross-examination took place in India and in US, and it was, of course, it went on till 2 o'clock at night. It did take place and finally things did work out. But yeah, it is a bit of a challenge where witnesses, and how to put documents to witnesses. Because there is a chance, there is a chance that when you put a document to witness, he may say that this is only a scanned copy or a photostat copy or something that I will not deny or accept it. So there's a bit of a challenge as far as cross-examination and putting of documents is concerned in arbitration proceedings, but these kind of things are required. And I think ideally virtual conducting of arbitration proceedings would be in the manner in which Ajinder was saying, where it is basically document-based and even expert-based, because expert reports are there on record to be examined, and virtual proceedings can go on in those cases.
Right. So, in fact, I probably want to digress a bit. I want to ask you, what do you think that is more important, a fact-based witness or a expert witness? I'm only talking about arbitration scenario and not a regular commercial suit or dispute before court. So, in an arbitration, what do you think the importance of a fact-based witness over an expert?
If I may, Ms. Dhir.
Yes.
Actually, I forgot to mention this one point. When it comes to virtual hearings, the other thing that is developing internationally is this, and I'm sure it's the same in India. all of the judges and the tribunals are saying, look, we are all experienced people. So this emphasis that parties are placing on cross-examination may be misplaced, because cross-examination at the end of the day is more of an issue of credibility. And really, at the end of the day, in terms of a contractual dispute, if you have the documents, I can read them, I can make the case out quite easily. So not so much terms of cross-examination, which is why now the thinking is expert witness, expert evidence is more important than factual. And as Ms. Dhir pointed out, experts are experts. So their reports are available and they are used to giving proper opinions before the tribunal, because this is their daily bread. You know, their job is expert testimony. So in that sense, KP, to answer your question, expert testimony is becoming more important than factual, because right now, because in this time and age, parties are very good at documenting disputes. You know, everyone knows when you have near dispute time, the emails, the correspondence starts going out to give, no, this was my understanding of the contract and this is how we performed, and therefore what you're doing today is contrary to contract. So that gives a lot of documentary evidence for arbitrators to fall back on. But what they don't have is evidence of custom in a trade, for example, or evidence of industry usage of certain terms and practices. And therefore, again, to me, I think expert testimony is becoming more important than factual testimony.
Just adding one point to it, what gets lost, I'm just giving the flip side of it. What gets lost, of course, like I said, expert witnesses are very important, but what gets lost in matters where fact witnesses are required is the demeanor of the witness is very important at the time of, because this is a very crucial issue for an award to be passed. So I think that bit slightly gets lost in matters where you need fact witnesses. And I agree with you that in those matters, probably virtual proceedings would not be the best of way of proceeding in the matter. And also, according to me, anybody who wants to delay the proceedings and not interested in going ahead with the proceedings has got an upper hand by saying that I will not participate in these proceedings because I have witnesses or have to examine witnesses who I want to cross-examine. Just wanted to put that point across.
Exactly.
Right. So if you have too many fact witnesses, probably this is not a virtual hearing could be a bit of a handicap in terms of looking at the demeanor of the witness while you cross-examine. So that's a very good point, in fact. And as we studied in law, that even in the CPC in India, they have said that judge, when the cross-examination happens, has to actually look at the demeanor of the witness when the questions are being put to him. So that is also a big consideration while deciding or while relying upon a testimony that is being given. So I think that, of course, is still to evolve, and I'm sure this will evolve in future. But we did discuss about certain, and Ajinder also mentioned about his problems that he's facing in terms of timing an arbitration, and where you have people sitting in across the world doing a virtual arbitration hearing. So what do you think are more practical issues that you face in terms of different time zones, start and finish time, breaks and length of each hearing? In an arbitration hearing, we are used to a 2-hour hearing, then a tea break, then a 2-hour hearing, then a lunch break, then again a 2-hour hearing, and then again a coffee break, and then so that's how we plan a arbitration day when we do a hearing or a cross-examination physically. But on virtually, when people sit across the world, and probably a 3-hour delay would be a midnight for me. So what do you think are the practical aspects that, and how do you manage it? I mean, how are you managing it when you see across the world people sitting? How do you manage your time?
I mean, the one drawback is this. At the moment, the recommendation is you work everything out on paper first, meaning the exact timetable. So start time, end time, break time, agree upfront. Why is that important? Because if I'm going to start my arbitration, let's exaggerate it, middle of the night, midnight, and the other person is starting it first thing in the morning, he's got an advantage. So the only way I'm going to agree to starting at a very late hour is that if we have only a short hearing, maybe an hour or two, so that I don't get worn out or I don't get sleepy, for example. So this means then your timetable gets stretched out. A hearing that is supposed to take 3 days or 4 days can now take 8 days because of time zone differences. So this is a problem that cannot be solved because the time zones are something that we've got to live with. And what we have to do is practically sit down and discuss what is reasonable. And this is where the greatest challenge is, because if a party wants to delay, everything becomes unreasonable. And so time zones, not an easy problem, but you have to face it head on with the other side.
Right.
So yeah, KP, that's like exactly, time zones is a bit of a challenge here. And just repeating myself, that anybody who wants to delay the issue can always delay it. And rightly pointed out by Ajinder that whatever would have taken 3 days because of the time zones and all that could take 8 days, 10 days, depending upon how you agree to fix a timetable. And the timetable has to be agreed much in advance and cannot be just randomly fixed if the time zones are too far away, far apart. And I think it's a bit of a challenge here again, I would say, as far as virtual proceedings are concerned. But that challenge would have been there in physical proceedings also, because if there are, I would say, what is the good side is that costs are reduced. So there is no need to be physically present. You may be little problematic on the times you're conducting those hearings, but as far as costs are concerned, this substantially reduced in case if you're placed far away physically. I think both sides to the.
That's exactly right.
Yeah. And probably next question I'm moving towards is one of my key concern areas in terms of, do you think that art of oral persuasion or advocacy is under threat in a virtual hearing, and especially if now we also hear a lot where people say that for a smaller arbitration dispute, probably we can only do a documentation based arbitration. People file documents and written submissions, and then arbitrator decides on the basis of what is being presented in written form to him. So do you think that art that we all learned, and we read about people, that how they were able to persuade a jury in the past and now the judges, so do you think that is under threat, or do you see any handicap while virtually presenting a case, and probably the forcefulness that shows in our expression and the movement of our hands probably has, or the way we shift while we argue. So do you think that is under threat in any way in virtual hearing? Ms. Dhir, probably I would want you to answer first, because I have assisted you in many matters and I know how do you conduct a court hearing. So probably what is your take on it?
Definitely, I would say that there is a handicap there, because your mannerisms, the passion that you present the case physically, I would say the vibrations across, you see the judge's face directly, you know the way he's moving, then you can change your, the way you are saying something. I think there is a bit of a handicap in virtual hearings and physical hearings. I think physical hearings have a great advantage over able to persuading a judge otherwise. I don't know what Ajinder says on that.
Actually, even before the pandemic, in Singapore and in international arbitration, what is happening is I do feel the art of advocacy is actually going down, because right now the written is carrying more impact than the oral. I don't think it's right, but that unfortunately seems to be the development of matters. Just to give you an example, just last year I had a hearing before, it was a domestic arbitration, not international, but the hearing was conducted before 3 arbitrators, and one of whom was my former boss. Now, the other side, the lawyer was a little bit, with respect, weaker, and she was not presenting her case well. So what happened then was the arbitral tribunal just told me and says, don't worry, everything is going to be on the written. Let's speed up. I don't want you to give long submissions. And that, unfortunately, is what is happening. Apart from advocacy turning to submission, judges are also now, and arbitrators do the same, they're compensating. That if you have a weaker advocate on the other side of the table, the judge or arbitrators tend to step in to try and balance the playing field. And so as a whole, things are moving in Singapore towards submissions. So in a sense, cross-examination skills and even oral advocacy skills are diminishing in importance. It's an unfortunate thing, and I don't like it, but it's something that's here to stay.
That's true. And people who appear in courts regularly are finding it very difficult to, argue virtually, because I think like I said, the body movements, the way
Exactly.
the judges are responding or the arbitrators are responding to your submissions makes a lot of shift to what you're arguing. If you find that he's not, with you, then you
That's
try to
right.
make arguments, which I think sometimes get lost in the virtual hearings.
Right. So, but what do you think that, I mean, this is of course of the arbitrations that are pending. But if I talk about what do you think that if we have to enter into a fresh start an arbitration in now, or probably enter into an agreement now. So what do you think that one should keep in mind for the purpose of taking care of all this? A written, probably predetermined that there'll be an half an hour oral hearing.
Yes.
There'll be. So do you think that for going forward, parties should, apart from deciding the arbitrators, these tech savvy, his age is to be considered. And do you think that all these factors should be built into an arbitration, sort of a mitigation factor, so that when a dispute actually arose, what can be done? So what is your take on it?
Actually, sorry if I may, actually, KP, that is the recommendation nowadays, that you come up with a proper protocol that covers all these issues. And it's helpful in a way as well, because if you can agree to all this upfront, then when it comes to a challenge on the award, it's much more difficult to set it aside because you've had an agreement on the procedure. But then again, as we all know, if you're going to cover everything, including hearing times, whether there can be agreement practically is another problem. So to me, I think in the more international cases where you have both sides have a lot of money at stake and want to get a result, then in those kind of cases, the protocol becomes easier to implement. But in another type of case, for example, an estate dispute that is going for arbitration where there's a lot of emotion and anger, for those kind of cases, very hard to see any kind of agreement on this kind of areas. And so, yes, it is going to be more developed, but it's going to be developed on the basis of the case specific. For the more commercial cases, you're going to see a better protocol in place.
Right. Ms. Deep,
so KP, my view is, I see ODR has been in place for a long time, online dispute resolution. I think the future would be, in my view, that that online dispute resolution would be the way forward. And I think because in online dispute resolution, apart from the acts or whatever, entire procedure, rules, everything is already prescribed. So there is no, I mean, there is, of course, arbitrator has a leeway to prescribe his own procedures, but if anybody is agreeing to an online dispute resolution, I have seen those rules and everything in place. It really works. I think the new way would be, in fact, in the fresh contracts, is an online dispute resolution would be a very good way of moving ahead in these matters.
Right. But with
Ajinderpal,
online,
on that.
Sorry.
Ajinderpal, what is your view on online dispute resolution?
I think it's here to stay. I mean, in every country you hear this word online dispute resolution. It's become almost second nature to all of us now, especially in the legal field. So you're right, Ms. Dhir. I think it's going to become even more developed in time, and it's as practitioners we need to get used to it, because it's not going to go back to the old style.
Well, it won't go back to probably the normal. It'll remain as a new normal. But on the online dispute, I mean, if you do every virtual hearing and online, probably there is some difference in terms of how you treat it. So, but do you think that it does bring in its own challenges in terms of age of dispute of seat versus venue? Internationally, I believe it is well defined, but in India there have been not much of a clarity, and to be honest, at times people don't clarify or specifically mention the seat of the arbitration, which leads to a lot of dispute which goes on for years. So I want to take Ajinder, your take first, and then go to Ms. Dhir, because India has its own challenges in terms of seat and venue dispute. But do you think on an virtual hearing, on an online platform, how do you take care of a seat? How do you define it? And if you have not defined it, what do you think should be the way forward?
I think KP, just again, we had it was good that we had this conversation, especially with Ms. Dhir just before this presentation. And as we discussed, if the contract specifies the seat, then actually this becomes a non-issue, because seat is the legal term. And if you have any issue in terms of how the arbitration was conducted, or you're going to set aside the award, is the seat, the country in the courts, the country in which the seat, as in the country specified as seat, those countries' courts will have jurisdiction over the arbitration. The problem is, at the moment, a lot of people are theorizing that even if the seat is specified, but you have arbitrators and counsel and witnesses all over the world, then you have a problem, because one issue is, has the seat changed, for example, or are you now facing an issue of multiple seats to a non-issue? If the contract specifies the seat never changes. Because as we all know, you can have a seat, say in America, San Francisco, but you can have the hearing in London, no problem. Physical hearing in London, but seat San Francisco. The problem is, like you pointed out, if the seat is not specified in the contract, then you have a problem, because a lot of parties can then take advantage to say, no, the seat is perhaps London, because 3 out of the 5 witnesses were present in London and 1 arbitrator was there as well. So it's the place or maybe closest connection. So that is going to be the debate. And the recommendation again is this: if you do the arbitration clause properly from the start, meaning you have the governing law and the seat properly specified, then this issue should not arise.
Right. And is it your view on how do we deal with seat and a venue dispute?
So Ajinder is right. I mean, as far as the seat is concerned, it's specifically described in the arbitration clause. The difficulty arises when the seat is not described, because most of the people confuse seat with venue. Your venue could be anything; it makes no difference. So the seat is what is described in the contract. Like in a virtual proceeding, everybody may be in a different country or a different city. That doesn't give jurisdiction to that city or a country to decide the other issues. So the seat is specifically described, and if seat is not described, then it is open to challenge to anybody to challenge the award, saying that the seat is the seat where we conducted the hearings physically. Or I can't really answer the question. If 4 people are situated in 4 different cities, what is his jurisdiction, unless seat is determined? So I think I will have to leave the debate at that, because it's going to be a difficult cause if the witness is in one place and the plaintiff is in one place, defendant is one place, arbitrator is sitting in one place. So unless seat is described,
contract also happened online, and then there's a default. So
I don't know whether cause of action, the original CPC will apply, or what will apply is a bit of a, I would say it's a bit hazy at this point of time. When we move on and see matters being conducted like this, we will understand what would be the, but seat is normally very specifically described, and we should not confuse it with venue at all.
Yes.
Right. Correct. So that's a very important takeaway. I think everyone who's drafting an arbitrator, whether an arbitration agreement, whether a lawyer or a party negotiating a contract, I think seat is the most important factor that they should keep in mind. But I have so many other questions to ask you, but I think the time is a constraint. So I'll ask you some certain questions which are very relevant now in terms of pandemics and during the pandemic. And we never thought the pandemics would stretch for so long, especially in India. It was a 1 day lockdown, 1 day curfew, and then 2 days after it was a lockdown, which continued for over a month. And still the restrictions have not, all the restrictions have not been lifted. So what do you think are the remedies available to the parties? And my question is to Ms. Dhir, in terms of seeking interim relief before courts and tribunals under Section 11, or appointment, or Section 9, any interim dispute. So if considering travel constraints, what do you think is your what's your take on it, that in pandemic times, how the courts are dealing with interim injunctions and reliefs?
So courts are dealing very efficiently. In Section 9, where petitions have been filed, and where they see there is a need to preserve the assets or need to pass orders with respect to any injunction being sought by the party who's approached the court, they are granting those injunctions. And recently, I think one of the judgments, Delhi High Court has passed an injunction against invoking the bank guarantees. So, and of course, these hearings are taking place on virtually, and Section 9 reliefs are being granted because these are urgent petitions where you are asking for courts to And we have dealt in Delhi itself and a whole lot of Section 9 petitions we are doing at the moment, and courts are in case they feel the need to preserve the assets or other requirements, they are granting those injunctions.
Right. And Ajinder, what's your, and how quick are the tribunals in terms of granting interim injunctions and probably an emergency arbitration situation, especially in pandemic when movement of everyone is a challenge. Probably the first time the entire civilized world was under lockdown.
Actually, on this part, because the system was already developed for interim relief, in arbitrations, emergency arbitrator relief has already been built in. So the pandemic has not affected this bit of the process. You can get your injunctions, interim relief within 24 hours. No difficulty there. And again, hearing takes place online. The courts, in terms of courts, there was a bit of change. It used to be you had to appear physically before the judge for interim relief. Right now, there is a dual process depending on the judge's preference. We either do it through online, or if the judge requires it, we can be present before the judge. So not much has changed. Interim relief is still being granted quite easily and quickly. In that sense, it's still the old normal in that sense.
But courts were accepting physical hearings in Singapore. They are allowing people to come and do physical hearings.
Yes, we have an exception under our COVID restrictions that for essential hearings, the court is allowed to hold them physically. But again, these are very small hearings. For example, if the court wants to hear injunction, no more than maybe 3-4 people in the courtroom. That's where the change is. Maybe you cannot have big teams. You certainly cannot have a hearing with 50 people in the courtroom. So if it's less than 5, the hearing can go ahead at the judge's discretion. If he prefers to go online, we can do that as well.
Right, which I think is a very good thing, that if access to justice is not denied even in this pandemic time, especially emergency reliefs or interim orders, which brings a lot of immediate relief to the aggrieved party. So I think that's a very excellent job that they are doing. And of course, the interim relief regime for arbitrations is already well defined even before the pandemic. But what is your take on enforcement of an award? So do you think that the enforcement has been affected or will be affected in future of an arbitration award?
I think by enforcement you mean on the asset, right?
On the asset, and probably asking for other party to pay up.
Sure. On the seizure side, if you're looking at a Singapore-based asset, land, property, or even shares, there's no change. There is again an exception. The court bailiff and authorized representatives can go with the court bailiff to seize the property or even seize chattels like the house, furniture, whatever. Shares also no change. So in that sense, if the asset is in Singapore, the pandemic has not affected it. But if your asset is international and in another country, especially a bigger one, I think like in India, it may be a problem depending where you're situated. And Ms. Dhir is better placed to answer that question from that aspect. If the asset is in India, what happens?
Yes.
So I would just start by saying that as far as execution of awards and enforcement of awards is concerned, one of the major issues which will come up is in case those awards have been passed in virtual hearings and the party was not inclined to do a virtual hearing and a direction has been passed to, would be an objection to the fact that he was not given a proper representation or that he was wanting witnesses to appear, and then he may object or delay the enforcement of awards. So this is my first point as far as enforcement of awards. Since it's a very crucial point because like I said that it's easy for a party to say that I was not given effective hearing because it was fact-based witness. I wanted to present that and I wanted to present that. And even otherwise, as far as actual possession is concerned, would be a bit of a challenge because possibly the person whose property is to be attached may say that I have nobody there. You can only attach it if I'm here. I'm just giving you an example that I need to have people there, and I can't send anybody there because of these times and all that. So again, there could be a bit of a challenge there. And in fact, even in enforcement awards, again, virtual hearings have to be before the court. For enforcement of award, you have to file before the court. And enforcement of award may not be taken as an urgent hearing. You know what I mean? A section 9 may be taken as an urgent hearing, but an enforcement of award may not be taken as an urgent hearing and may, notice be issued another party present. So this is my view that there would be a lot of challenge for enforcing an award once that award comes by.
But I think, in fact, India also doesn't have that exception of bailiffs, going and seizing a property during the pandemic. So there was a complete lockdown, and in fact, virtual hearings was also a lot of issues. It was only very extreme urgent matters that were placed. So enforcement of awards and even decrees were sort of under suspension during lockdown in India. But things are now back to normal. I mean, the lockdown have been eased, except in containment zones, is what is the norm. So I think now execution and awards can be executed going forward. So that's what is from India. So I see that I think we have a lot of questions which have come up, and time is very less. So in fact, during the registration also, certain people have asked us certain questions, and considering the time, I think I won't be able to take all the questions. But there is one thing that reoccurring question that comes up is that, and this is to Ms. Dhir in terms of objections to an arbitration. So do you think that during the objection, when the objections have been filed against an award and are pending, so do you think that the execution can go on, or probably the same court can hold the execution and also hear the objections?
So KP, these are very absolutely individual cases. Section 34 are objections, and execution award is a separate matter. So these are two separate cases which have to go on independently of that. And of course, objections under Section 34 have to be filed within the timeline as prescribed under the Act. So if it is not filed within that timeline of what is prescribed under the Act, then executing court will take its own view on it and proceed in the matter. But if the objections are being heard and then under the new amendment, if there is a specific stay, then the executing court can't proceed. If there is no specific stay, then the executing court can proceed. So as far as Section 34 is concerned and executing is concerned, these are two separate proceedings which go on a separate foot. They have to be two separate proceedings. They have to be.
So I think, right. So that is the amendment that was brought in under the Act, and I think Singapore already has the same process. I mean, two are separate proceedings, and you have to specifically seek a stay to the execution. But Ajinder, I want to ask you, how do you think the arbitration sector has evolved during pandemic? Do you think the arbitration has dropped considering lockdowns? Because as I mentioned, in India, probably the litigation burden, at least fresh filings, were virtually stopped for some time. So do you think that that's the same effect that had in Singapore?
No, actually, in terms of the arbitration sector, actually there's been a pickup. There have been more filings, and I think Ms. Dhir pointed to one of the reasons maybe because it's cheaper, nobody has to travel. But while the filings are at a record high, the pace in which the arbitration is proceeding has slowed down. Meaning, for example, appointment of arbitral tribunal, the institutions like SIAC, ICC are taking a lot more time to confirm the appointment because most of the ICC and SIAC staff are also working remotely. So while filings are at an all-time high, the way the case is progressing is slower. That is the big difference.
Right. So I think that's a big insight that the filings are on an all-time high during pandemic. So, I mean, with that high note, probably I want to close the session for today. I'm seeing that we have reached almost a lot of time. And thank you so much to the both of you for taking out time and joining us for this arbitration. And thank you for all our participants who have participated. I tried to see that I could accommodate a lot of questions, but I think the discussion was so interesting. I thought that 5 minutes would be enough, but I see they are not. So all the people whose questions have not been answered them separately via reply email after this webinar is over. And I think we had a very excellent discussion and a lot of key takeaways from it. And I think Ajinder set it right by saying that arbitration this is what, I mean, virtually it has been accelerated. There's an acceleration because of COVID, and certain excellent points were made in terms of how efficiency can be improved in the arbitration matter. Especially, we have to ensure that so what is the cyber protocol? Who will speak? You have to ensure your system efficiency when you do a virtual hearing, and also what are the points to be considered while choosing an arbitrator now going forward. And Ajinderpal made certain points in terms of the age of the arbitrator. Ms. Dhir said that knowledge of an arbitrator is very important. So I think these are very key points that a person should consider while while doing an arbitration agreement now going forward. And Ms. Dhir also said that you can have a specific virtual hearing clause in your agreement, and Ajinder seconded it by saying that that would improve, that will ensure that later on there is no challenge to the arbitration award. Because world over, we've seen that at least in various jurisdictions where the courts don't look at merits of an award, but if there has been a procedural lapse, the award can be set aside. So, and the entire process would come to a naught. So I think that's an excellent point, that we can have a specific clause with respect to virtual hearings. And of course, then parties have to, the obligation is cast on parties to ensure they have robust system to do those hearings. They can't say that I couldn't, had an access to a robust virtual hearing system. So that's an excellent discussion we had. And of course, on the seat, that while whatever you do, you enter into a physical arbitration contract, or you enter into a virtual arbitration contract now, you have to ensure that you define your seat clearly. Where do you want? Because that would be the jurisdictional court that will look at all the procedural aspects and also to the challenge of your award. So I think those are very key takeaways that we have from this discussion. And I'm looking forward to, if anybody has any questions, they can of course drop us an email and we'll be happy to reply. And all the questions that we already have, I will personally get back to them with my panelists. And thank you everyone, and thank you my panelists once again, and thank you Lex Witness for organizing this very efficient online webinar. So thank you everyone, and have a great day.
Thank you very much. Thanks.
Thank you, Mr. Kohli. Thank you, Maneesha ma'am. Thank you, Mr. Ajinderpal.
Thank you very much.
Mr. Kohli, seeking your permission to end the webinar for everybody now. Thank you.
Yes.
I will now be ending the meeting for everybody.